Okay, I would say we could start, John.
Okay, well, thank you, Chris. I'd like to welcome everybody once again to the Healthy Aging Committee's second webinar in so many weeks. This webinar is planning for the future, wills and power of attorneys and things like that, our lawyer questions. First of all, I'd like to welcome everybody who's logged on. Oh, I shouldn't. That's not a good idea to bump the table like that. I'd like to welcome everybody who has logged on. Welcome. Welcome to my kitchen. We are very relaxed here. I don't know if some of you were with me last week. You saw me drinking my wine today. No wine. My wife says to abstain, so I shall. I'd like to thank Bear as our sponsor this week for hosting, or not hosting, putting on this event. Again, I'd like to thank the committee, the Healthy Aging Committee, for doing all the background work. This is, again, as I said last week, this turned from an entire event to a quickly changed over COVID event, which is turning out quite well. I think it is a norm for us more and more. Those of us who are still in the workforce are doing this more and more, so it's becoming more and more comfortable, and we're finding our place. At this time, I think I want to introduce Gerrit Theule as our key spokesperson today. Gerrit is a partner for Wolseley Law. Gerrit grew up in Wolseley and currently lives in Wolseley. He loves Wolseley because he gave me his bio and he talks about 8 pages of Wolseley. But Birds Hill is good too.
Birds Hill's great.
Birds Hill is great too, just to let you know.
I'm a big fan.
Gerrit was a former bencher, he calls it, a board member of the Law Society of Manitoba, and has been on a number of committees, committee boards, including currently sitting as the member at large at the Manitoba Bar Association, Wills and Estates. I'll keep going. Wills and Estates section executive, serving as the treasurer of Shakespeare in the Ruins, sorry, and formerly serving as a chair of the Lower Seacourt School. Also volunteers with a number of organizations, including Coaching Robert Andrews, Robert A. Steen Kids Sport Team, and assisting with both the Legal Help Center and the Community Legal Education Association. He does sing opera, so we will ask him at the end to prove that, because he does say that in his bio. I'm going to hand it over to you, Gerrit. The floor is yours.
Thanks so much, John. I wish I'd given you the funny bio. That's not, you know. So thanks so much, everyone, for joining us tonight. As entertaining as my home office is, and as entertaining as I am, we're actually going to be working off of slides tonight. So I'm going to we're going to screen share here, and away we'll go. There we are. Yay. Hey, look, it's slides. Can everybody see that? Chris, can you give me a nod? John, yeah, we're good. Perfect. So tonight we are talking about wills, powers of attorney. We're going to talk a little bit about healthcare directives as well. So as John said, I'm Gerrit. I am a lawyer over at Wolseley Law, and my primary area is in wills and estates, as well as elder law, which encompasses things like later in life loss of capacity, or any sort of issues relating to sort of later in life legal issues. So tonight we're going to talk a little bit about estate planning, as well as other tools that we use when we talk about estate planning. So things like powers of attorney, healthcare directives, other things as well. We're going to talk a little bit about what some do-it-yourself options are, why sometimes they're a good idea, why sometimes they're not. And then there'll be lots of time for questions as well. So I'm as much as I spend a lot of my day on Zoom, we are doing a lot of estate planning wills intakes and things like that via Zoom these days. It is just as for all of you, I'm sure, not my favorite way to go about doing these. Talking to a screen is without any feedback. But the nature of it really, I think, is the questions at the end work pretty well. I know Chris has a couple of questions that were submitted ahead of time, and I'm happy to try and touch on it as I go through. But I love questions. I love chatting with folks much more than I like talking at folks. So without further ado, away we'll go. One thing I have to tell you is this presentation is for informational purposes and does not constitute legal advice. My lawyer told me I had to tell you this. Basically, I'm not your lawyer. I'm giving you some legal information today. What I will suggest is that you go talk to somebody if you require specific legal advice for your situation. With the boring stuff out of the way, the 5 W's is what we talk a little bit about when we talk about estate planning. The who, what, where, when, and why. You're familiar with them, and we're going to go through them in reverse order. So I won't belabor sort of what they are, but we're going to go through them in reverse order today, starting with the why. So when we talk about making a will, making a power of attorney, making a healthcare directive, the idea is that you're doing it somewhat for yourself, and we'll talk a little bit about how you can help yourself with those things. But really, it's about dealing with helping out your family, giving gifts. It says give gifts of lasting value to your family, but really it's about making life easier on the people that you care about, whether it's friends or family or organizations. The other reason we plan in advance is to prevent hurt feelings and manage expectations. So when we talk about not just wills, but also powers of attorney and healthcare directives, if you can lay out your thoughts ahead of time, it really does protect. It protects feelings, because then everybody knows this is what you wanted. And oftentimes, the hardest part about the absence of a lot of these things is not necessarily knowing what it is that the person wanted to have done. And that can be really difficult on the folks who are left to make decisions. Again, whether when we talk about wills or powers of attorney or healthcare directives. Part of the reason we do it is to prepare when you're legally competent to make decisions about your assets and to dispose of assets how you want to, not just in terms of with a will, but with a power of attorney, or make decisions with how you want to, not just in accordance with the legislation that's out there. We're going to talk about protecting yourself with some of these documents later on. Having it done properly really does lead to making sure that your wishes get followed. The biggest issue, the one that surprises folks most often, is to save on unnecessary costs. With estates, without a will, there are a lot of extra steps that get involved with having to administer an estate. Power of attorneys, though, are the ones that often surprise folks. In the absence of a power of attorney, we're going to talk a little bit about how having a power of attorney is actually a real cost-saving measure. And then ultimately, if you have minor children, then it's really, really, really important to have these things done. The major reason being that you're going to want a lot of say in what happens with minor children should something happen to you, and these documents are the way in which you can best do that. When? Right? So right now, it's like planting a tree, right? The best time was 20 years ago. The second best time is today. Really, the idea is that you can think of all of these things as wills, powers of attorney, healthcare directives. You can think about them a little bit like insurance. You can think about them in terms of being something that if you don't know when you're going to need, but you're able to make one today. So when we say right now, that's kind of what we mean when we say that. Oftentimes folks ask about when should we take a look at the plans again? When should the plans sort of be revisited? And often what we're talking about is anytime you have a major life change. So even if you have a will, even if you have a power of attorney or a healthcare directive, major life changes are really sort of what triggers folks taking a look at redoing them, or at least just taking a look and making sure they're still applicable, because a lot of these things that you see on the list here are things that can really affect those documents. So having kids is a huge one, or kids becoming over 18, or kids that develop a disability. Divorce, marriage, cohabitation is a huge one. Marriage in Manitoba revokes a will. So if you have a will and then get married or become common law with somebody, that will goes right out the window. Anytime we talk about, you know, doing something, if you have a business, doing something with that is often a time when you take a look at it. Other businesses or farms or anything like that, all of those things, any changes in the way in which you hold things is often when we say, hey, it's good to take a look at those things. And then every 3 to 5 years, just open it up, take a look. Nobody likes making, let's be frank, right? Nobody likes making a will. Nobody likes revisiting a will, but you know, you open it up every 3 to 5 years and go, hey, has anything changed? Does this still do what I want it to do? It doesn't have to be a scary thing. You can kind of, you know, you open it up and go, yep, nope, that looks fine. Usually that's okay. That's usually enough. So just reviewing it periodically is often a really good plan to make sure that it still does what you need it to do. When we talk about where, we're talking about a couple of different things. Where do you actually go to plan effectively? Lawyers, accountants, financial planners, there's lots of great books out there. We're going to talk a little bit about some of the do-it-yourself options a little later on in the presentation. It says here in the slides, you'll spend more to prepare your plan if you go and talk to a professional up front, but may avoid preventable mistakes. One of the themes you'll see over and over and over again from me in this presentation is as a person that makes wills, I have a healthy disdain for will kits, but as a person who goes and litigates wills, I love will kits. The idea of actually writing your own will on a piece of paper, not using a will kit, is often far better than using a pre-structured will kit. We're going to talk about that in a little bit. But when we talk about when we talk about wills and powers of attorney, we're also often really, really concerned about residency. And so people that need to pay a special attention to these sorts of planning ideas are people who may have other citizenships, particularly US citizens, and anybody that might have beneficiaries, family members, executors that don't live in Manitoba, particularly if they live outside the country. And so these are all things that sort of, if they apply to you, might be things that make you go, huh, maybe this is something I should take a look at. Because especially if you have beneficiaries that live outside of Manitoba or Canada, and especially if you have somebody that you want to either be your attorney or manage your estate who lives outside of Manitoba, then it's really important to take a look at those things, because sometimes those things aren't even possible if you don't have a will or power of attorney in place. Next up is the what. Did I miss one? No, I didn't miss one. Perfect. What? So when we're talking about these things today, we're talking about what is your estate, and really when we talk about what you have for the purposes of dealing with a will, with dealing with a power of attorney, what we're talking about is what are the things that are important to you that you want to make sure go where you want them to go, and what is your plan to do that? Different things have different ways in which you can accomplish those goals, whether it's holding something jointly with somebody or making a will or dealing with things like that. But really what it comes down to is taking a really good look at what you have, and then how do you plan to give it away. So, but the tools, when we talk about the tools as the second point here, is there are often different tools to accomplish those goals. And you know, a lot of people are familiar with what we call the big three: a power of attorney, a will, and a healthcare directive. And we're going to talk about those in the upcoming slides. But there are other ways that you can plan things too, including life insurance, where you give a gift outside of your estate. Joint accounts are a really common one, and I have almost never done one of these presentations where people haven't asked me about joint accounts. So there is a little bit about a slide later, holding things jointly, say with children or parents or others. Making gifts during lifetimes, we're going to talk a little bit about that as well. And so we're going to talk all about the tools that we use when we're talking about making plans for the future. And the who. Who is often the real stumbling block. Often people know that they want to make a will. They know that they want their, say, for instance, spouse to be their executor. But when we're talking about more complicated situations, oftentimes those are the real ones that you need to give thought to. choosing who's going to be your attorney under a power of attorney, who's going to be your healthcare proxy, who's going to be your executor, who's going to be guardians for minor children are often really, really complex discussions with folks. The right attorney, and when we say attorney throughout this presentation, what we mean is attorney under a power of attorney. Well, not a lawyer, but an attorney under a power of attorney, and those are really important things to think about, because just because somebody may seem like they are the person you should appoint to those things doesn't always mean that they're the best person for the job. And so we'll talk a little bit about that. Often tied into that is who should be your healthcare proxy when we're talking about a healthcare directive. So a healthcare proxy is the person who's going to make decisions about healthcare treatment if you're not able to do so. And that can be a really, really, really important conversation and thought process to go through, because they're going to be the ones who get to make a lot of decisions if you can't, that will have a really dramatic effect on you, particularly later in life. We'll also talk a little bit about who you want to benefit, who should help you, who can help you, both in terms of when you're making those documents, but also as you go through and the documents start to be needed. It really, depending on the nature of what you have and how complex they are, it really is worthwhile giving an awful lot of thought to those things. And then the one that also very frequently comes up in this presentation, when I give this presentation, is do you have children or other beneficiaries with a disability? There's a lot of planning that goes into powers of attorney and wills when there are children or beneficiaries with a disability, because what we really don't want, almost nobody's intention is ever to get in the way of any benefits that people might be entitled to, and without any planning, that's sort of a thing that can happen. So let's talk about the individual tools. We're going to drill down into them individually, kind of in order here. So powers of attorney, lost will and testament, commonly called a will. Healthcare directive is what it's called in Manitoba. You may be more familiar with them as being called living wills, partly because in Ontario they're called living wills, and in some American jurisdictions they're also called living wills. But in Manitoba we call them the healthcare directives. They're called the healthcare. They're legislated under the Healthcare Directives Act. So that's why we call them that here. And we're also going to talk a little bit about will substitutes, as I mentioned, joint accounts, joint tenancy, things like that. So let's start with powers of attorney. Powers of attorney are often, figuring out which document is used when is often sort of is the first sort of path forward. Now, power of attorney is arguably more important than a will. I tend to liken them as more important than a will. And the reason why is that the power of attorney, as it says on the slide, is a document that provides somebody the authority to deal with your financial affairs or property while you are still living, but might be unable to adequately deal with your affairs yourself. The idea is that a power of attorney only exists while you're still alive. It is a document that says that somebody, whether it's a spouse or a family member or a friend, has the authority to deal with your financial affairs, to deal with your property, but it doesn't act after you've passed away. Once you pass, the power of attorney passes. And so what we're often dealing with here is later in life loss of capacity. They can be used for a whole bunch of other things, but very, very commonly, powers of attorney are meant to deal with either later in life loss of capacity or temporary loss of capacity as a result of, say, an accident or surgery that may lead to a recovery at some point, but currently where someone is not able to manage their own affairs. There's some language around them where we talk about enduring versus springing powers of attorney. Enduring powers of attorney, though, are another term as well, that where even though at law a power of attorney is supposed to terminate when somebody loses capacity to manage their own affairs, Almost every power of attorney that gets drafted in 2020 is meant to continue through somebody losing their capacity. Historically, powers of attorney are hundreds of years old, and they're meant to be, hey, I'm off to fight in the Crusades, somebody tend my flock, here's a document that says you can. We don't do a lot of flock tending with powers of attorney these days. And so what we mostly use them for, as I mentioned, is the idea that if someone's lost capacity, then that's when we bring out the power of attorney. And so one of the most important things that we're always looking out for is have we specifically mentioned in them that they need to endure past someone's incapacity? Because if we don't, they actually don't. And it's just a weird quirk of legal history. I'm not a very good legal historian, but that one I always remember. Powers of attorney can also do other things. General or specific is the heading. Most of the powers of attorney that we do are what we call general powers of attorney. They are designed to be as all-encompassing as humanly possible. They are to deal with my car and sell my house and go to the bank and buy me groceries and tend to my alpaca farm. See, I said we didn't do a lot of tending of flocks, but the alpaca farm's a great example. I can buy feed for the alpacas, I can shear the alpacas, I can do all the things that I need to do. But sometimes people find powers of attorney useful if they're going to, say, be out of the country. So, hey, Bob, here's a POA to sell my house while I'm out of the country. So if I were going to be away for some time, I could talk to John and say, John, I want you to sell my car while I'm out of the country, but I don't want to give you the authority to tend my alpacas. So John, here's a really specific power of attorney that just says, I give John the authority to sell my car and take whatever price he thinks is reasonable for it. But for the most part, those aren't the powers of attorney we draft. For the most part, we draft powers of attorney that are really, really broad, with the idea that being that we make it as easy as possible for the person to manage our affairs on the whole. So I very often people are concerned about powers of attorney. They say, well, doesn't signing a power of attorney mean that I give up I'm giving my authority to somebody else to do things? And that's a bit of a misconception. Just because you signed a power of attorney doesn't mean that you give away your rights to manage your own affairs. It means that you've given somebody else the authority to do so. And so we often talk about powers of attorney as being either springing or immediate. And a springing power of attorney is the one that a lot of people are more comfortable with. It's a power of attorney that comes into effect only once a certain precondition is met. And oftentimes that precondition is that a doctor has determined that you're unable to manage your affairs. And so now the power of attorney comes into effect. And until that condition has happened, until a doctor, in most cases, has signed the form saying that you're not able to manage your own affairs, then really the power of attorney just sits in a drawer and is of no effect. Oftentimes, though, depending on the situation, some people may prefer powers of attorney to be immediate and not springing. And very often what we think about when we think about that are couples that have been together a really long time and they're getting on in years, and you don't need the power of attorney quite right away, but we know that capacity when we're dealing with folks isn't a light switch. It doesn't turn off and on. You have some good days and you have some bad days often. And what an immediate power of attorney, as opposed to a springing power of attorney, will let you do is use the power of attorney on the good days and not have to use it on the bad days. And so as much as springing powers of attorney are often the thing that people are more comfortable with, my comfort is almost always to suggest an immediate power of attorney, so long as the life situation makes it make sense. Oftentimes, folks have questions about multiple attorneys, having more than one person act as an attorney for them, so that more than one person can go ahead and help you out with things, right? If you need to run to the bank and you have, let's say, 2 kids, and maybe one can help you most of the year, but is tending to their alpacas in the summer, so I need the other person to act as well. Oftentimes, multiple attorneys under a power of attorney are a good option. But it can be really, really difficult for them if the powers that are laid out to them aren't really clear. And so oftentimes people will name all of their kids joint attorneys because they feel that that's the most fair. And one thing that you hear me say again and again and again is none of these documents are really about fair. They're about what you want, and they're about what is best for you. And so very often, naming multiple people just to name multiple people isn't a great idea, but very often there are a lot of cases that naming multiple people does make a lot of sense. Question is, do you need one? And I get that question an awful lot of the time. It says you may hold some of your assets jointly. So if you hold most of your assets jointly together with a spouse, sometimes that is more than sufficient to deal with things. The big one that we often though have to deal with is if you own a house with a spouse, they're not able to they're not able to sign away your rights in a house just because you happen to own it jointly with them. And so that's the thing that we're often really, really concerned about when we talk about a power of attorney. Tax filings are another one that can be problematic. So oftentimes, like I said, we consider a power of attorney to be often more important than even getting a will done, because it really, really can affect your the way in which you live your day-to-day life, if that makes sense. It really does mean that that you can do a lot of things that you wouldn't be able to do otherwise without one. Before we jump on from powers of attorney, I do want to just talk about, because I saw the next slide is wills. When we think about the relative value of wills and powers of attorney, oftentimes people say, oh, I have a will and I don't really need one. The thing about a will is that depending on your particular worldview, you're not around to see the effects of a will. But a power of attorney and naming the right person in a power of attorney is really, really important, because they are almost, in an awful lot of cases, going to have a really, really visceral effect on how you live your day-to-day life in your later years. Very often they will be the ones that decide what groceries get bought and what money gets spent on what things. And so when we talk about a power of attorney and considering a power of attorney, it can be really, really important. In the absence of a power of attorney, your loved ones are left going out and getting a court order, which can be significantly more expensive and also really, really restricted. As I said earlier, a power of attorney, we're often trying to make things as broad as possible to make them as comfortable as possible. But a court order for something like this in the absence of a power of attorney can be really, really narrow. And so oftentimes when people ask which is more important, my thought is almost always that a power of attorney is more important. That to be said, will is the one that everybody seems to think about, and that's okay. When we think about wills, powers of attorney, healthcare directives, almost everyone is thinking about a will. And as I mentioned, the will is versus the power of attorney is the power of attorney stops acting from the moment that you pass away. So when you die, your power of attorney dies with you, and that's when the will starts to speak. It operates, as it says here, to dispose of your assets in a manner you set out in a document. So the will is what determines who gets to manage your affairs. It also determines who gets what. So oftentimes we think about wills in terms of who gets what, but there's always really interesting considerations when we're making wills. Blended families make for really interesting conversations. I would say some of my longest will appointments deal with stepchildren or second or third marriages, assets from before, particularly as they interact with it always brings out all the feelings. And so that does make things interesting. When we talk about, as I mentioned before, marriage, when you're talking about making a will, if you're planning on getting married, or if you've recently been married, getting married does revoke a will. So if you do get married, you do have to make a new one if you want it to be effective. Divorce, on the other hand, as much as people would like it to, does not revoke a will. So the law says that if you get married, your will is torn up and it's no good anymore. But if you get divorced, your will's still in effect, but it does do a really interesting thing that I find people find really, really satisfying. I find divorced people find really, really satisfying. And it treats your former spouse as having predeceased you, which people often seem to really enjoy. So it voids the gift to them. It basically removes them from the will entirely. So the will still stands as though they didn't exist. But there is a section in bold here that says, remember, separated is not divorced. So for the purpose of dealing with that, oftentimes people, when they move to separation, often deal with remaking a will, because until the divorce is final, it's a little more complicated than that, but until the divorce is final, we're talking about here is that they are not removed from the will until that point. You've heard me talk a little bit about being selfish in this, right? That the will and these documents really are for you. You don't have to make all of your children your executors. You don't have to make any of them your executors, quite frankly. They can act, if you do decide you want to make them executors, they can act jointly, they can act in series, they can do any, or you can name none of your kids or your spouse or anyone as an executor. Ultimately, these decisions are up to you. And it's really important to remember that these decisions should often be made with an eye to who is best suited to the task, and not necessarily who you feel you really need to or should name as these things. So let's look at what a typical will looks like. Wills often follow kind of a pretty predictable pattern. They typically revoke a previous will. So right off the hop, it says, I revoke all my previous wills. One thing that I often see in wills that were drafted more than, say, 5 or 10 years ago is a clause in there that says, I'll revoke previous wills and other testamentary dispositions. So if any of you have wills that are more than 5 or 10 years old, you may see that clause in there. And that has proven to be a little bit of a problem, because it's been found that clause revokes life insurance designations. So oftentimes when folks use life insurance to sort of help plan out a will, the wording in their will, if it's an older will, can often sometimes work to frustrate that. I would say any will that most people would draft these days would not include that language. But it is something to keep an eye out for if you do have an older will and you're pulling it out that every 3 to 5 years and going, hey, does this will do what I want it to do? Something that revokes testamentary dispositions might be a clue that you need to redo your will. Then it goes ahead and names your executors, the people that will handle your affairs. Executors are also called estate trustees, and that's really because they act as trustees of all of your possessions until they get distributed in the way that they're supposed to. Following that, we deal often with then specific gifts. So if there is a watch that was your grandfather's that needs to go to cousin Ned, or a family wedding dress that needs to go to your sister, that is where they get dealt with next. They need really specific things to specific people. And once all those specific gifts are given away, what we do then is deal with the residual gifts. And the residual gifts are what is left over at the end. And so I often like to think of an estate kind of as water in a swimming pool. And so what we do is we take all of someone's possessions and put them in the giant swimming pool as the water. And then we have these specific gifts. And so this water over here needs to go in this little hot tub over here. And this watch over here needs to go in this bucket over here. And so we're going to take those out of the pool. And then once all those little containers are filled up in the specific gifts, what we have is a great big swimming pool. And then that pool gets divided up amongst the people who you decide should share in the division of all of your assets. Following that, then often we have what we call miscellaneous provisions, and what they often are end runs around the law. So very often we have things that exist in the law that we don't necessarily like how they operate, or they make things a little harder than they have to be for the executor. And so we use this section of the will to say, hey, what we really want to do is make life easier on our executors. So we use other provisions to go ahead and do that. When you're thinking about making a will, there are a number of things to think about, as you would expect. Specific gifts of property, you can give them away in your will, but you can also give them away before that. It says, make sure you don't forget something that might cause fights later. And I'm a huge proponent of having discussions with people before you pass away, because doing it the other way with the Ouija board is just way too hard. Having discussions about sort of specific gifts or sentimental gifts that you're giving away in a will is a really important thing to do. And often I encourage people to do it even before they sign the will. So if they come in and talk with me about making a will and there's some specific things, I'm almost always going to have a talk with them about, hey, have you talked to all your loved ones about your plans here? Because what we don't like is surprises, particularly surprises when it's too late to do anything about them. We also want to think about the way life insurance can impact on an estate. And we also want to look at consistency. We want to make sure that when we're dealing with a will and the plans that are made in a will, that they're being held, that it's being done consistent with your other plans. So for instance, if you own something, if you own a bank account jointly with somebody and you pass away, the law says that that just goes to that other person automatically and doesn't fall into your will. So when we talk about consistency, it's really important to sort of do a thorough assessment of what it is you have and how you hold it to make sure that the plans that you're making will hold up. We also want to talk about trusts when we're talking about a will, especially if we have people under 18, because the law says you can't just give a gift to somebody under 18. If you don't make a specific plan for them, the public guardian and trustee, lovely folks though they are, will just step in and take it over and manage it until the person turns 18, and then they'll just hand it all to them. And oftentimes that's not the thing you want. You may also have what my partner who drafted this paragraph called spendthrift beneficiaries, like he's writing in a Dickens novel. I love him to pieces. Basically, sometimes giving a large gift in a will outright may not be the appropriate choice, and so oftentimes we take a look at that. I've mentioned before, and I'll mention again, beneficiaries with a disability. So if you have children or beneficiaries that have a disability, you may have heard the term a Henson Trust. Henson Trusts could have their own presentation all on their own, but the long and the short is that anybody who's expected to receive long-term disability benefits, particularly government benefits, but not just government benefits, oftentimes other granting programs and things like that, often have an asset cutoff that can often be sheltered against by putting a particular kind of trust in place. And so if you have a child or somebody that you want to leave money to that has a disability, talking to a lawyer that can set up a Henson Trust is going to be so very important, because it's almost never anybody's intention to cut off somebody's benefits by giving them a gift. Cutting people out, speaking of cutting off, cutting people out. You may not want to provide for some people that life would otherwise think that you may be expected to give a gift to. The interesting part about that is that that's okay, with some exceptions, and what we're often talking about is a spouse or a child who's dependent on you. Other than that, you get to choose. It's the lovely part about it. Wills are not public documents until after you've passed, and you get to decide what it is you want to do with your stuff. And so oftentimes people come and they have a lot of questions about, I don't really want to include this person in my will. Do I have to? And the answer is almost always no, you don't. And then life estates. Life estates are another real strong consideration that we deal with when we talk about estate planning. It may oftentimes with subsequent spouses. So if you own a house and you've gotten remarried, you want to make sure that spouse has a place to live, but you may want something else to happen to the house after you pass away. Very often we'll use something called a life estate to make sure that they have a place to live, that they can continue to live in the house, but that ultimately that the house doesn't necessarily pass to them because you have other plans for your house. One of the other considerations that we deal with when we're talking about estate planning is plan giving. And plan giving is really thought of as gifts to charities. So oftentimes folks who are either closely associated with a charity, or if they have been personally impacted by something, them or their family, or if they've consistently made gifts to a charity throughout their lifetime. Very often folks want to give money to a particular charity or organization that you love and support, right? The nice part about that is in Canada, if you make a gift to a charity, you get a tax receipt, just like you do in life. You also do after you pass. The part that surprises a lot of people is the largest tax bill you will ever get is what's called your terminal return, because anything that you've sort of been dealing with on a tax deferred basis, like an RRSP or well, not an RRSP or a RIF, or investments. If you've been investing in things and you've not liquidated them and they've been dealing with capital gains, or a cottage that you bought for $35,000 in 1975 and is now worth $500,000, all those things incur a massive tax bill. And so when you make gifts to charities in your estate, you can often use those receipts to reduce that income tax liability, as the slide says, in some cases quite significantly. We talk about why you should consider it. I love this quote from Colleen Bradley, and it says, people think that leaving money to a charity will diminish what they can leave to their kids, but because of Canada's tax regulations, you can give money to a charity that you'd otherwise give to CRA. And if your net income in the year of death is lower than the amount you give, your executor can claim a rebate against your previous year's income and add that to your estate. So it can really, really benefit an estate to deal with some planned giving situation. Beyond you know, the benefit to the charity that I'm going to talk about on the next slide, from a purely selfish perspective, dealing with a charitable gift in your estate can have massive financial benefit to the people that you're leaving, to the non-charity people, to your friends and family who you may be leaving gifts to. It also lets you leave a gift, and I like this part on this slide, a gift you might not be able to afford while you're alive, right? Particularly in the case where we're talking about not leaving to a spouse, but leaving to kids, particularly grown kids who may have assets of their own. It lets you leave a gift that you may have wanted to leave in life, but really didn't have the assets to deal with in life. In addition to having the largest tax bill of your life when you pass, you'll also have access in most cases to more assets. And so it really is important to think about not just the gifts to friends and family, but from a purely selfish perspective, how a gift to a charity might be able to help you. When we talk about you know, how does it benefit the charity I care about, I don't think this will come as a surprise to anybody. Charities rely on donations every year, and we know this. But the annual gift that you may give can really pale in comparison to an estate gift that we see sometimes. Again, the idea being is that particularly if you're using it for tax planning purposes, but even if you're just using it as a large demonstrative gift, knowing, you know what, they're not going to get my annual $50 or $100 every year, a lump sum gift that can come in an estate can be absolutely life-changing for a charity. They can very often use it as a capital contribution to something that they wouldn't be able to do otherwise. Oftentimes charities also use it for an endowment fund so that it can continue to give every year. There are so many things that folks can do, or that charities can do with gifts from folks that come sort of in a large lump sum, that it really is something that I feel particularly passionate about in terms of those plans. It's not right for everybody, and it's not something that everybody does. But if you're in a position to do so, like I said, it can be a massive boon to the charities that you deal with, as well as also maybe providing benefit to yourself as well. So moving on from wills, let's talk a little bit about healthcare directives. As I said, in Ontario, they're called living wills, which is how we often know them. They're also called living wills in a lot of American jurisdictions. So if you've heard of them on TV, they're often referred to there as well. And what healthcare directives do is appoint somebody to make a decision about your healthcare treatment in the event that you're not able to do so. it names what we call a healthcare proxy, so someone to make that decision. And oftentimes it also lays out guidelines that you may have in the event that you're not able to make those decisions on your own. Very often what we suggest, particularly for older adults, is if you make a healthcare directive, you leave it on the fridge. And the reason that we do that is that's where first responders typically go to look for those healthcare directives, particularly if they're looking about heroic measures instructions. So if the best example I can give you is that if you have a no heroic measures clause in your healthcare directive that you don't want, say CPR, but you've also named but you've only named a healthcare proxy as someone to make the decision. If paramedics come to your house to respond to a call and they're not able to get a hold of the healthcare proxy, they are going to provide that life-saving care. And so it's really important to sort of flesh those out with your thoughts and what your wishes are within the document. You can get healthcare directives prepared, as the third point says, at a lawyer's office, but it would be very rare for me to do so. Some lawyers do so; they sort of tack it on as just an extra fee. I personally don't love that. A will has some pretty specific execution requirements. A power of attorney needs to be witnessed by basically either a physician or a lawyer. But a living will doesn't even require a witness. It can simply be completed, and just as long as it's signed with your signature, is effective simply by virtue of the fact that it exists. And so I'm a huge fan of for about 98% of people, the provincial government has a blank fill in the blanks healthcare directive that I think is great. It is 1 page long. It has instructions on the back. It gives you an opportunity to name healthcare proxies. It asks you some questions about some of the things you may want to consider as far as treatment decisions, and then gives a place for you to sign. It's 1 page long. It's really easy to do. And if you take one thing away from the presentation tonight, it would be go online, search for that. I'm giving the URL here, but if you search for Manitoba Healthcare Directive and you print it off and fill it out tonight, I will, if one of you does that, I will have done my job here, because really that healthcare directive is such a valuable document that doesn't need to be done by a lawyer. There's never any reason for a professional attorney to do it, with a couple of exceptions. And so what we sometimes will do when we're talking about a healthcare directive is for people who are going to have really particularly advanced care directives, that's when we take a look and decide to get a lawyer and a doctor involved in drafting them. So if there are really specific healthcare needs that really can't be dealt with by sort of an overarching 1 page healthcare directive, then it might be appropriate to have it professionally drafted. I'm really not going to talk too much about will substitutes. There's other sort of estate planning measures that you should be aware of. So joint accounts, we often talk about joint tenancy, so owning property with somebody else, trusts and gifts in life. Joint accounts and joint tenancy are really the big ones that people come in and ask about. There are a bunch of risks to holding things jointly, and so generally it's not a thing I recommend. The big one is that you're exposing those assets to that person's creditors, particularly in the event of a relationship breakdown. It can become family property in a divorce. So you put your kid on your bank account and then they get divorced. That can become shareable family property, and that's never the intention. So your child's ex is suddenly entitled to half of that account, and that's kind of the worst case scenario. Joint tenancy is another one, particularly that I don't love, partly because there are real strong tax implications of it. Without going too far deeply into it, oftentimes when you own a house, you have a personal residence exemption from the gain in value that it has, so you don't have to pay tax on the increase in value. But if you own a second property, you do. And very often putting a child or somebody else onto that property gives them a second property that suddenly they're going to have to pay tax on the gain in value of. And that's something that sort of people don't often aren't often able to consider when they do that. So if you're contemplating doing those things, the one thing I would say is just talk to a professional who can talk you through sort of what the risks and benefits are. Sometimes part of it, I'm not going to talk about trusts at all because they are bananas complicated. But sometimes people like to give gifts in life too, and there can be some really strong arguments for doing that when we talk about ways that we can plan about life. Or about our assets while we're still living. I'll touch very briefly on DIY stuff. I actually don't mind handwritten wills. In Manitoba, you can make a handwritten will as long as it is entirely in your handwriting and signed and dated at the end, and it's a valid will from a form, if not necessarily content standpoint. Will kits, though, are often a disaster, and I really don't like them. The reason being is that oftentimes they are either out of the US or out of Ontario, and their rules are different from ours. And they are also really, really easy to fill in incorrectly or leave blanks or to deal with things that are inconsistent. And so if you don't have very many assets and aren't looking to make a really complex plan and just want to write down on a piece of paper all in your own handwriting, I name my spouse as I name my spouse Jim as my executor and give everything to him, and then sign and date it at the bottom. That's going to be valid. There's going to be some hiccups along the way when it comes time to probate it. I'm not going to lie to you, but that's a totally valid will. Will kits, on the other hand, can be a little bit of a mess, but it is important when we're talking about doing it yourself. The thing that we're most concerned about is not planning from a tax perspective, which is often a concern, as well as not having consistency within the will. So oftentimes wording that we may have seen other places can lead us to use wording in a will that might not be consistent with other parts of a will, and can lead to confusion, can lead to court applications. Is the thing that we're really looking to avoid is court applications. So you avoid spending a couple $100 on a will, but your estate is dealing with $2,000 or $4,000 worth of court application, and that's the thing that we're looking to avoid when we talk about planning. So how do I start? You speak with your accountant, your financial advisor, or lawyer if you want to do some estate planning. I'm always happy to chat with folks if you want to talk to me, but if you don't want to talk to me, that's fine too. Talk to really any of those people, or find someone you trust to talk through it. Somebody who sort of does it for a living is a really good place to start. The nice part about getting that advice is partly the people who give you that advice are insured. So if they mess up, your beneficiaries have someone to rely on, which is great. If you do know what you want to do and just have a simple estate, you can, like I said, we talked a little bit about doing it yourself, but you can also just have them draw up a quick one for you. And usually a basic will is quite inexpensive. It is important to note, just as I touch on a quick drop, as I mentioned, and I can't emphasize enough, you can make your own will. You cannot make your own power of attorney. You can make your own healthcare directive. You can basically however the heck you want. You can make your own will, like I said, as long as it's all in your own handwriting. You cannot make your own power of attorney. The law doesn't allow for it. And at the very least, start thinking about the end of your life, despite its difficult and uncomfortable nature. I deal with these things literally every day, and I am just I hate the thought of dealing with my own stuff. So I deal with my own mortality. So I deal with that of others. So I know how difficult it is. But really, estate planning, the sentence couldn't be more true, is one more way you can show love to those you care about. The idea being is you're not left leaving them guessing at decisions. You're not left leaving them to sort of pick up pieces if you put everything sort of in a plan and in place. So now I'm going to repeat the disclaimer. The presentation for informational purposes only. Do not operate heavy machinery while listening to this presentation. You're advised to seek a lawyer, and away we go. That is, hey, it's me. This presentation is brought to you by me. You can come and talk to us. We have a lot of folks in our office who are more than happy to chat with you, but ultimately chat with someone you trust. I'm definitely someone you can chat with, but the important part is that you actually go ahead and do it. So I will I'll leave the slides there, and we can chat about questions, because I love questions. I would much rather do questions than slides.
That was absolutely fabulous. I got like 12 pages of notes here.
Oh, good.
And you and I are going to be good friends.
Are we? Oh, good.
Yes, we are.
I'm giving you my alpacas, John, so.
Well, there you go. You can have my chickens.
Perfect.
There you go. I just wanted to, I forgot to mention this at the onset. There is a tab at the bottom that says Q&A. So if anybody has any questions, please type it in there and we'll address the questions as they come up. Probably a little moot point now, but we still have some questions.
Perfect.
I do have a question. We talk a lot in wills and such like that, end of life things. Most people talk about assets and what do I do to distribute my property.
Mm-hmm.
My question is, how does a debt get resolved with that?
That's a great question. Debts, for the most part, and there's always an exception, right? Lawyers are the worst. There's always an exception, but for the most part, debts are required to be paid off before anything can be distributed. So if you have a house and that house has a mortgage on it, that mortgage needs to be paid off. Oftentimes that's done by selling the house. But when we talk about estate planning, that's when we sit down and go, okay, so you want to give this house to your kids, but you also have it mortgaged at 90%. Maybe that's the time to talk about things like life insurance to pay those things off. And so when we talk about planning, that's a huge part of the planning. It's doing an assessment to see whether somebody has enough assets to do the things that they want to do. But those debts really are required to be paid off before you deal with the assets. There are some ways around that really depend on situations. Life insurance being a big one because it falls outside of an estate, but even that's not foolproof. But it's a great question. Debts absolutely need to be dealt with first in almost every instance.
Okay, so in an instant that the debt outweighs the assets, then what happens?
Yeah,
Who's responsible?
that's a great question. Insolvent estates, I went to a 3-hour presentation on insolvent estates that was meant for lawyers, and I'm still certain there's a dozen other presentations I could go to on the topic. The long and the short is that if I won't necessarily speak to it from a person making a will standpoint. What I will say is that if someone's been asked to act as an executor, or if somebody is in line to be the administrator of an estate, and it appears at first glance that the estate owes significantly more than it has, I would always caution them to consider very strongly whether or not they wanted to act as an executor for that estate.
Okay.
Creditors do have the right in Manitoba to apply to administer an estate if nobody else will, and they can put it through a bankruptcy process. But I would caution an executor against. I would caution an executor to consider whether or not they want to lead that process, or whether that might be best left to somebody who has an interest in receiving the estate. I will say it's really important that if you're named as an executor and you're not sure if you're going to act just on that point, that it's important that you don't take any steps to act like an executor. So if you're considering not administering an estate because it has, say, $50,000 more in debt than it has in assets, it's going to be really important that you understand that you're not going to be able to take Aunt Mildred's brooch out of the house and give it and keep it for yourself, or give it to your cousin. Because that's going to be seen not only as being an executor, but it's also going to be drawing down the assets of the estate, which you may not be entitled to. Fair
enough. Thank you for that.
Yeah.
I'm going to read off one of the questions. My parents are really worried about the family cottage once they're gone. They seem worried that we won't be able to afford the inheritance tax. Can you elaborate on that?
Yeah, one of the things that I touched on in the presentation is just to give everybody sort of the same sort of starting point in terms of what we're talking about, is when you own a house that you live in and it's your primary residence, you're sheltered from having to pay tax on the increase in value. So we call that a capital gains tax, because the house is capital, and the gain in value that you get ordinarily would be taxable. But the government said that for your primary residence, you get an exemption for that. So you don't have to pay tax on it. You have to report it to CRA when you sell it, but you don't have to pay the tax on it. A secondary property like a cottage means that tax is payable on it. And so very often, as I mentioned, the largest tax bill that anyone's ever going to see is after they've passed away. And a big part of that is things like cottages, where suddenly the cottage, the example I gave, the cottage that was bought for $35,000 in 1972 is now worth $500,000. And the tax on that, you know, the difference between $500,000 and zero and $500,000 and 35,000 is about $500,000. So the tax on that $500,000 increase is not going to be insignificant. So oftentimes that's when we take a look at planning in terms of what to do. That capital gains tax is going to be paid out of the estate anyway. But oftentimes that's when we start talking about things, like I said, about life insuring those capital gains. So it doesn't need to be sold if you want to keep the cottage in the family. We also talk about family cottages. I could do a whole hour on family cottages alone. They're really interesting. Family dynamics always come into play. Sometimes people put them into cottage trusts so that everybody sort of gets an equal share. Sometimes they divide out the cottage equally amongst the 5 kids, and then everybody's left owning a fifth of a cottage, and that's a whole other kettle of fish.
Yeah.
But as far as affording a family cottage, it is one of the real things that we see an awful lot of these days, because the increase in the value of those cottages has just been out of control. And oftentimes my suggestion is to look at life insurance, but it's certainly not the solution for everybody's situation.
Yeah, fair enough. Another question came up. How do you name a health advocate as you age?
Yeah, so a health advocate or a healthcare proxy is named by a healthcare directive. As I mentioned in the slides, a healthcare directive can be as simple as you writing on a piece of paper who you want to name and signing it. But I do love the fill-in-blank government form that I linked to there. You can find it with a quick Google search. We link to it on our website, even though it means that we're not doing that work. I'm happy to link to it because I love it so much. And I love it for a couple of reasons. Number one, it's really easy and lets folks do it themselves. But the other thing I really like about it is because it's the provincial government form, physicians and healthcare providers are really used to seeing that form. And so the official government one-page healthcare directive, when they see it, they know exactly what it is they're seeing. They're saying, okay, you filled in the part where this person's a healthcare proxy. That's who I know is your healthcare decision maker. You've made decisions about sort of life-saving treatment. This is where I expect to see it, and bam, there it is. So while you can do it just on a piece of paper, while you can go to a lawyer and have it drafted, that fill-in-the-blanks government one on the website is something that I love to pieces.
Fair enough. Good.
And it's free, which I also love.
And it's free.
I love free.
Me too. One more question. How do you, here comes the infamous P word. How do you avoid the assets going to probate? Nobody likes probate.
Yeah, well, it's important to note that probate in Canada and Manitoba in particular is different from probate in the U.S. So Canada doesn't have death taxes in the same way that or estate taxes.
So we're just going to wait a few minutes for people to log in. For those who have logged in, welcome.
The executor and approves the will.
The second of two for the Healthy Aging Committee.
Really is.
Just give me a nod, Chris, when you think
approval on either the will
we're populated.
or if there is no will, the court stamp of approval on who is proposed to come forward and manage the estate.
Welcome.
Manitoba does charge a probate fee at the moment. They're talking about getting rid of it. From a policy standpoint, there's a lot to be said about that. But Manitoba's probate fees are already, so even if they don't get rid of them,
and my computer and my wall clock don't
criminally low. They're 0.7%. They're less than 1% of the value of the assets.
Yeah, well, that's weird.
Passed. And so while there are ways to
somewhere out there in outer spaces, there's a central
will alternatives that I mentioned, holding things jointly with somebody or things like that. It is often not worth the risk that you take for those alternatives to avoid the 0.7% probate fee. But for the most part, if you are dealing with a third party, so whether it's a financial institution whether it's the land titles registry and moving property or things like that, there really is no avoiding sending it to probate, because those third parties are going to require the judge's seal of approval that this will is a legitimate document. So there are ways to sort of mitigate the tax implications of it, but we don't really have an estate tax in Canada. The probate process is a slightly different process in Canada than what people often think of, and it's not necessarily something to be afraid of.
Okay, fair enough. Let's see if there's any more questions. If not, I have the one question that I ask. The do as I say, not as I do. This is a question for you. Don't have to answer.
Okay.
But how current is your will?
Well, funny you should ask. My will is less than a year old.
Oh, good for you.
My wife's is a little bit older than that. My wife's is about 2 years old. I remake my will every time I make a major change to my will precedent. So if I go to a professional development session, I come home with 5 or 6 ideas for things that we need to make a change to in the will that I use to draft to draft our other people's wills from. And the first thing I do is I put it into my will to see how it works. And so partly it's easy for me because I get to do it, and then I make someone who's hanging out in my office come in and witness it. It's a little more difficult to drag my wife down to the office to do hers. But the long and the short is I redo my will anytime that I come back with an idea that I think is a good one, that I think should be in other people's wills. I use it to update the precedent that I use to draft their wills, and then I update mine at the same time.
Fair enough.
Ultimately, that's what it's about, right? It's about making life easier. Anytime we're doing any of these documents, it's about making life easier for the people that love us, right? And so if I can make a change to my will, but just by editing a few sentences and hitting print, I'm absolutely going to do that.
I have a confession to make. My wills is probably about 25 years old. So it's you and I have to make an appointment.
Take a peek at it. It might still be valid. It might still do exactly what you want it to do. And what
only if my kids want to go live with my brother.
The good news is those clauses tend to age out. So very often folks will come in and they will say, hey, would you take a look at this will and tell me if it still does what I want it to do? And yeah, that's a perfectly valid thing to ask the lawyer who drafted it. Take it back to the lawyer who drafted it, John, and ask them if this still does what you need it to do. And if it doesn't, then make a change. And if it does, you're home free. Then at least you know. And knowing is half the battle, right?
Yep. What is the range for cost for a will?
That's a huge question. So I can give you what ours typically look like. We put our prices up on our website, and we say over 85% of our wills are $250.
Okay.
When you do the healthcare directive at the same time, we charge an extra $100 for that. But on its own, it's $250 as well. But prices are all over the map. There's an excellent article in the Free Press, talks about sort of how good a job somebody can do as a professional for a will that's really underpriced. Ours are by no means the most expensive, not even in the ballpark of the most expensive.
Okay.
But wills can, for people with sufficiently complicated situations, wills can run north of $1,000. It just doesn't happen very often.
Yeah, but on average, like for an average person, you're looking at about $250, $300.
Yeah, so for like I said, for over 85% of the wills we draft in our office, so it encompasses not just basic wills, but wills with the kind of complexities that we know how to solve off the hop, if that makes sense.
Yeah.
Are flat rated. They're flat rated at $250.
So I brought myself and my wife in to come to see you. We couldn't bundle it. It would have to be 2 wills separately.
Yeah, in Manitoba, in fact, no jurisdiction in the country lets you create multiple people in one document.
Okay.
The idea being is that there's no way to really express the individual person's wishes that way, even if they are supposed to be identical. It also, if the will gets revoked, it creates a whole big bunch of problems. So yeah, wills are made individually. They're not made jointly.
Fair enough.
Yeah.
Chris, do we see any more questions coming up? No.
I know, sorry, it was taking, I'm sorry. No, I don't, there aren't any more questions.
No questions.
Okay.
I
Well,
must
we
have
did-
told you everything there is to know.
Hey.
a lot of the questions came up on the chat line, so yeah, we did very well there.
Yeah.
That was
Perfect.
very good. How can people get a hold of you?
They can look me up. I work at Wolseley Law, so they can do a search for that. We're at wolseleylaw.ca, or they can give me a call. Yeah, the easiest way is just to do a search for Wolseley Law, because my name is just a disaster to spell. So you can look at Wolseley Law and you can track me down. I'd be happy to chat with anyone.